My name's Sarah Bolt. I'm hosting today on behalf of Bristol Law Society. This is the second webinar this year where we're focusing on private client, and we're welcoming 3 people from Michelmores. So we've got Alexa Payet, Georgia Wookey, and Hannah McElroy. Sorry for my pronunciations. A few admin things before we get started. The webinar is being recorded. It will be circulated with some slides afterwards. If there are any more questions, we've had several submitted already. We'll look to introduce those to the speakers at the end of the session. There is a Q&A function on this webinar, and if you want to raise anything more, please do that at the end or during the webinar, and I can address those at the end. With that all in mind, I'll hand over to the speakers. So I believe it's Georgia that's taking off the first slide.
I'm just going to do a brief introduction, actually, Sarah. So thank you so much for the introduction. As Sarah said, I'm Alexa Payet, a partner in Michelmores Disputed Wills and Estates team, and I'm joined today by my colleagues Georgia Wookey, an associate in the team, and Hannah McElroy, a solicitor in the team. And today we're going to talk to you about the procedure for dealing with an estate when the original will cannot be located after the testator's death. The aim of this webinar is to explain what to do when a will is lost or misplaced, and during the presentation we'll provide an overview of the case law and the practical steps that need to be taken when making an application to prove a copy will. So Georgia, perhaps you could kick us off and tell us what can we do if an original will can't be found?
Of course. So it's pretty rare that a will can't actually be found. The original will is usually in a strong room at a law firm that prepared the will, or at a home, so at the deceased's home, or perhaps held at their bank. Most people will generally lodge their will with their solicitors, keeping a copy of their will amongst their papers at home. After they've died, their executors will then contact the solicitors who have the will and secure the release of the original. If neither original will nor a copy can be found, then the likelihood is that no will was made, or surprisingly, a large number of people share their intention to make a will. So it's often a family discussion, we need to do that, but there's a difference between saying that you're going to do it and then actually doing the execution of the will and instructing a solicitor or preparing it yourself. So before making an assumption that there is no will and that the intestacy rules govern the distribution of the deceased person's estate, it's sensible to check with the deceased regular solicitors to see if any will was made, to carry out a will search, to include a notice on the missing wills notice board, and to check with other law firms in the area to see if there was ever any if they were ever instructed to prepare a will. It's also sensible to insert an advert in the Wills and Whereabouts section of the Law Society Gazette, and to contact the probate service in case they may hold it. It's also worth considering contacting a search organisation to handle those steps. Where a copy of the will can be found, but no original can be found, then the question is whether the original was merely lost or whether it's actually been revoked. So if it's assumed that the original will has simply been mislaid, then it's possible to admit the copy of the will to probate, and provided that the probate registry is actually satisfied that there's sufficient evidence to rebut the presumption of revocation. The law assumes that if an original will previously in the possession of the testator can't be found, then it's been revoked. Although compliance with strict legal formalities is required to create a valid will, there's next to no formalities for revoking a will. And so tearing up a will or otherwise destroying it with the intention of revoking it will suffice. Despite this, the case law demonstrates that the courts require the clearest evidence of revocation. Hannah, can you tell us about a case that deals with this?
Yeah, so the recent case of Jones and Tracy and others, which was a 2023 case in the High Court, the court found that the presumption of revocation is not rigid, and that Master Martin in that case felt that it was artificial and unnecessary to adopt the two-stage test of firstly deciding and considering the evidence as to whether the will had been in the custody of the testator and therefore the presumption exists, and then moving on to reconsider the same evidence and potentially further evidence to consider whether the presumption had then been rebutted. In this case, Master Martin considered that the days of the presumption might be numbered, but in that case he did then proceed to to apply the conventional two-stage test. And so for now, that is the law that we should be using.
So when do problems arise? In many cases, the issue of whether or not a lost will has been revoked is not in practice, and in the family context, a big issue. If the will merely reflected the intestacy distribution, then it's not too big of an issue. So, for example, on the death of a surviving party to a marriage, a will or the will has left everything to the children, because those tend to be standard provisions. So where family members who inherited on intestacy are entirely willing to enter into a deed of variation, that's also not an issue, because they can reach an agreement between them to meet any legacies contained within the lost will. So the problems tend to arise in situations where the lost will is potentially at odds with the statutory rules of intestacy. So, for example, where there's a cohabiting couple or where somebody is leaving the entirety of their estate to friends or to charity because they don't get on with their family, for example. So if the last will is held to have been revoked, then the estate will pass under the intestacy rules and the named beneficiary won't receive anything from the will. Hannah, is there any case law on the presumption of revocation?
So the leading case in this area is the case of Sutherland and Lord St Leonard's, in which the former Chancellor Lord St Leonard's made a will in 1870 and then he made 8 further codicils between 1870 and 1873. These were kept in a deeds box at his home, and it was kept on the ground floor, and other family members did have access to the box, so the box wasn't particularly secure. After Lord St Leonard's death in 1875, the box was opened and the codicils were in it, but the will hadn't been found. It was held without hesitation, both at first instance and on appeal, that there was no destruction by Lord St Leonard's with the intention to revoke, on the basis that no careful chancery lawyer would be likely to have destroyed his will, without also then destroying the codicils and making a new one. Which does bring us to an important point, which is that a codicil to a will can survive the valid destruction of the will, where it makes testamentary dispositions which can stand alone independently of the will. In Sutherland and Lord St Leonard's, there was insufficient evidence of revocation, and the lost will and the codicils were found to be valid. So, Georgia, if an original will can't be found, when is a copy will going to be admissible?
So the answer to this depends on whether the will is found to have been revoked. There are broadly 3 ways in which a will can be revoked. So the first is by executing a new will, the second is by marriage, and the third is by destroying the original will with the intention to revoke it. In respect of revocation by destruction, Section 20 of the Wills Act 1837 states, "No will or codicil or any part thereof shall be revoked otherwise than by burning, tearing, or otherwise destroying the same by the testator or by some person in his presence and by his direction with the intention of revoking the same." It can be difficult to determine whether a will has actually been destroyed with the intention that it is revoked or whether it has simply been lost. And to revoke a will, the will must be firstly torn or otherwise destroyed, and secondly, destroyed with the intention that by doing so, the will is revoked. There must be an actual destruction of the will. So, for example, torn apart as opposed to merely being crossed through with a pen, and that's in Cheese and Lovejoy. The testator must also intend to revoke. The presumption can be rebutted by evidence of destruction by accident such as fire or flood, and in that case, the contents of the missing will can be proved by a copy, or even a draft or oral evidence. And that means that admissions of copies are fairly commonplace and standard in practice. The presumption of revocation also does not apply where it is more than likely that the will was not in the testator's possession, but being held by a third party, such as a solicitor. A will destroyed whilst a testator is of unsound mind is not revoked, and that's the same test of capacity as the capacity to make a will in Banks v Goodfellow, and that applies to its revocation. A will is not revoked if the testator destroys it on the basis of an incorrect assumption of fact, and if the revocation is conditional upon if the revocation is conditional upon the revocation having a particular effect, then it is only effective if the revocation has that effect, and that's in Rhys Sutherland's estate. And one case which does consider the destruction of a will is Blythe v Sykes. I think Hannah's going to tell us about that case now.
Yeah, so in Blythe and Sykes, it was held by the High Court that a certified copy of the deceased will would be sufficient to prove to probate where the original will couldn't be found after death. This was despite the presumption that where an original will can't be found after death, the testator deliberately destroyed it with the intention to revoke, which is what the claimant in this case sought to argue. The dispute related to the estate of Mrs. Agnes Moore, who died in January 2016. A certified copy of a professionally prepared will made by her in April 2008 was found among her possessions, together with a draft of the will and a solicitor's fee note for its preparation. The original of the will couldn't be found. In the will, Mrs. Moore had appointed her daughter, Miss Blythe, who was the claimant, together with her daughter's husband as her executors. The residuary estate was to be divided into 4 equal shares between the claimant, the deceased 2 other children, Mr. Moore and Miss Sykes, and then a 4th share went to Miss Sykes' former husband, Mr. Sykes, who was the defendant. The will had been made some 10 years before Mr. and Mrs. Sykes had separated. However, the deceased Mrs. Moore and Mr. Sykes had stayed in close contact with each other after the separation. Miss Sykes had predeceased her mother, dying in February 2015. The will contained the usual provision whereby if any beneficiary predeceased, their share of the estate would pass to their children, if any, in equal share, and so that share did pass to Miss Sykes' children. The claimant's case was that the revocation of the will took place after the Sykes had separated and after Miss Sykes' death, such that Mrs. Moore had died intestate. Any previous will would have been revoked when she made the now disputed will, and the revocation of the will does not resurrect the terms of any earlier wills. The effect of this would be that under the statutory rules of Japan intestacy, there would be no provision for the defendant, Mr. Sykes. Mr. Sykes, however, argued that the original will had simply been lost. The envelope in which the copy will and other documents had been found detailed on it clear instructions as to what to do if the testator's intention changed. It also bore a printed statement which said, "Your original/copy will is enclosed," and the word original had been struck through, leaving the impression that the envelope just contained a copy. The envelope also stated, "Keep a note in this envelope if the original will is deposited elsewhere," and there was no such note. The judge held that the obvious inference was the original will had remained with Mrs. Moore's solicitors, and so it was not traceable to having last been in her possession for her to have destroyed it with the intention to revoke. Accordingly, there was insufficient evidence to conclude revocation. This case serves as a useful analysis of the law on the revocation of a will, where there is very little recent case law and in the context of relatively narrow circumstances in which a copy will can be admitted, when the original can't be found without an explanation. The judge was also critical of the solicitors who made the will for the deceased for having no record of what happened to the original will, so it also serves as a warning to solicitors and people who are drafting wills to maintain accurate records as to the whereabouts of the original will. In this case, the claimant sought to argue that Mrs. Moore had intended to revoke the will because she didn't want the children of Miss Sykes to inherit, but only for the remaining surviving beneficiaries named in her will to inherit. However, this would not have been the effect of the intestacy rules, and so while the judge had already concluded that there was no revocation, he also went on to consider whether, if there had been a revocation, there was the necessary intention to revoke. In this respect, he held that there was not the requisite intention because the revocation was on the basis of an incorrect assumption of fact, namely the understanding of the operation of the intestacy rules, and or had been conditional upon the revocation having a particular effect so as to disinherit the grandchildren as opposed to disinheriting the defendant, which it did not have.
Thanks, Hannah. The burden of proof in shifting the presumption lies with the parties that are trying to propound the missing will. So if you have one side saying that the will cannot be found, it's revoked and the estate and the intestacy rules apply, but the beneficiaries of the missing will are arguing that the will hasn't been revoked, it's just been lost. The onus is on the beneficiaries to provide a clear and satisfactory evidence that the testator did not destroy the will. The court will then examine the evidence that has been produced and come to a decision on balance of probabilities about what is likely to have happened. The case law shows that the court will lean against an intestacy when they can, as they don't like finding that somebody died without leaving a will, particularly if it looks like a person went to the trouble of making a will in their own lifetime. It is actually really difficult to find a recent case where the presumption has been upheld, and in almost all cases, the presumption of revocation was found to have been rebutted. So it was almost always found that the will was not revoked. The strength of presumption of destruction varies according to how the testator has kept their will and how securely they kept it. And so the safer the security, the stronger the presumption, because it would be less likely to have been lost. In the case of a testator who can show that they, in the case of a testator who can be shown to have been disorganised or careless with their documents, the presumption that the will has been revoked would be much weaker. If there is a strong presumption of revocation, then in order to rebut it, particularly clear and convincing evidence would be needed to show that the testator didn't destroy their will. Hannah, can you explain how this was approached in the case of Roe v. Clark?
Yeah, so in the case of Roe and Clark, the court had to consider the presumption of revocation, where it was unclear whether or not the will had been in existence at the testator's death. The court held that the strength of the presumption in any given case depends on the character of the custody in which the testator had over the will. So essentially, considering what sort of person they are and do they look after their things. In this case, the character of the custody was very weak. The testator was not careful with his papers and had not attempted to keep the original will secure, so there was sufficient evidence to rebut the presumption that the will had been destroyed. The background was that Mr. Roe, the claimant, had been in a relationship with the deceased Mr. Clark for some 10 years prior to Mr. Clark's death in January 2004. Following his death, the deceased brother, Kenneth, had obtained letters of administration on the basis that the deceased had died intestate. The claimant sought to set aside the letters of administration and obtain a grant on the basis of the June 2000 will. The brother, Kenneth, relied on the legal presumption that as the original will couldn't be found, the deceased had destroyed the will with the intention of revoking it. The claimant gave evidence in court that the will had been kept in an old filing cabinet in his and Mr. Clark's house, but later moved to an old wardrobe. He told the court that when he went to look for it after the deceased's death, he couldn't locate it, and he claims that Kenneth had removed and destroyed the will. The court said that the legal presumption regarding destruction with intent to revoke was very weak. Whilst Kenneth had the motive and opportunity to remove and destroy the will, there was no positive evidence of the existence of the will at the date of death. The court was therefore not satisfied that the will was in existence at the date of death. However, it went on to consider whether it had been deliberately destroyed by the deceased with the intention to revoke it, or whether he had simply lost or destroyed the will without intending to do so. The court, accepting the deceased's continued objection of his relationship with Mr. Roe and his wish to look after him after his death, considered it unlikely that he would have deliberately destroyed the will. To do so would have meant allowing his estate to pass to his brother Kenneth, and they were not close, and in fact they had been very distant, and the deceased had previously taken formal steps to disinherit his brother. The court considered it probable that the will had been lost or destroyed by the deceased during his lifetime, but without the intention to destroy or revoke it. And the key reasons for this were that the deceased had not kept the will very secure, he had a history of alcohol abuse, and he had taken the unusual step of sending a copy of the will to Mr. Roe's mother. And the court found that he considered this to be sufficient, and that was why he was not overly concerned about the security of the original will. The court was therefore persuaded that the will had not been revoked, and it revoked the letter of administration, pronouncing instead in favour of the 2000 will. So if we have a client who believes that there is a will and they can't find it, or if there's a copy will available, what should we be doing?
So if you're faced with an estate where the original will cannot be found, the first step should be for the PRs, so the personal representatives, to conduct a thorough search of the property. And if the will still cannot be found, then a search company can be instructed to undertake a will search. If the will isn't found after these steps have been taken, then there are various things that can be done. So if there's a copy of the will, then it might be that this can be submitted to probate. But first of all, you'll need to carry out investigatory steps. So first of all, identify who was responsible for storing the will and into whose possession the will can last be traced, finding out whether the original was stored with the firm of solicitors who prepared it, kept by the testator personally, or whether the testator gave it to their personal representative, a friend or family member. As mentioned earlier, if a will is traced into the testator's possession, then the presumption of revocation is applied, and this means that unless there is evidence to the contrary, it would be found that the will was destroyed, and so the intestacy rules will apply. This could result in a situation where the estate is distributed in a way that doesn't reflect the testator's wishes.
A fairly recent case which addressed these issues is the case of Cooper and Chapman. And in this case, the court held that a will which could only be found in draft and electronic form on the deceased computer was formally valid and had not been revoked. The claim concerned the estate of Dr. Stephen Cooper, who had died suddenly of a heart attack on the 20th of July 2019. The first and second claimants were his two teenage children, and as they were minors, they were represented by their mother and the deceased ex-wife. The marriage of the deceased and Mrs. Cooper had begun to break down after the deceased underwent a sudden and catastrophic decline in his mental health in or around November 2014, and he was admitted to hospital as a psychiatric inpatient. Although he was discharged in January 2015, he continued to suffer ill health, and his wife issued divorce proceedings in February 2015. Mrs. Cooper moved with the claimants into a new home, and from around then the deceased stopped having any contact with the claimants. Later in 2015, the deceased began a new relationship with the first defendant, Miss Chapman, who was his partner at the date of his death. They were childhood friends and had just started to build a life together when the deceased tragically died. The claimants were seeking to propound a will dated the 4th of June 2009, by which he left his estate to them contingent on them reaching the age of 21. Mrs. Chapman, however, had counterclaimed that Dr. Cooper had made a will on or around the 27th of March 2018, which had since been lost, and she principally claims to prove its contents. Under the 2018 will, which was a homemade document, the deceased left his residuary estate to Miss Chapman, with specific gift to the school which he had taught and a children's hospital which had looked after his eldest daughter. It made no provision for the claimants and instead recorded that the deceased had deliberately failed to make provision for them because his will said that they had been sufficiently provided for by the divorce settlement. Miss Chapman claimed that the 2018 will was valid and satisfied the requirements of Section 9 of the Wills Act 1837. She said that it had been signed by the deceased on or around the 27th of March 2018, and he acknowledged its signature in the presence of 2 witnesses who were present at the time and attested and signed the document in the deceased's presence. In addition, because the 2018 will had been lost and was last known to be in the deceased's possession, Mrs. Chapman claimed that he did not destroy it with the intention of revoking it. The claimants disputed the validity of the 2018 will and also contended that if the 2018 will was valid, Miss Chapman couldn't establish the deceased hadn't destroyed it or that he didn't intend to revoke it. There were several disputes of fact in this case, but for the purposes of this talk, the key issue in the dispute was whether it was correct that, as Miss Chapman claimed, Dr. Cooper did not destroy the 2018 will with the intention of revoking it. The court found the will was formally valid, and the judge went on to consider whether the 2018 will had been revoked by destruction, and concluded that it was improbable that the deceased had destroyed the 2018 will with the intention of revoking it. Most likely, he didn't have any intention of revoking it. The judge came to this conclusion for the following reasons. Firstly, the deceased's lifestyle had become relatively chaotic, partly because of his ill health and partly because he was splitting his time between his own flat and Miss Chapman's home, so he was unlikely to have taken as much care with the 2018 will as many other testators do. Secondly, the deceased probably had a continuing wish to make significant testamentary provision for Miss Chapman. The claimant argued that gifts of large amounts of money he had made to her after the will had been executed suggested that he had revoked it, but the judge considered that this supported the conclusion that he had a continuing wish to support her. The claimant's point would only have been a good one if there was evidence that his relationship with Miss Chapman had deteriorated after March 2018 when the will was executed, or that he had begun to think of the claimants more favourably after that date. And finally, the revocation of the will would have meant that his gifts to the school at which he taught and the alternative provision that he'd made for the children's hospital would have failed, and the evidence suggested that he did continue to prefer these beneficiaries over the claimants. The judge found other points made by the claimant irrelevant to the question of whether he revoked the will, including that the deceased may have been financially vulnerable when he died, but this was not relevant to the question of whether he had revoked the will. The 2018 will was a temporary will, and it was not referred to after his death, but this also does not indicate that it had been revoked. And the fact that he did not make a later will was also of no consequence. Miss Chapman had told the deceased that she was upset that he had made no provision for his children, but this did not stop him from making no provision for them, and there is no suggestion to suggest that she sought to change his views, or that his views did change. This case demonstrates that the presumption of revocation where a will is lost is relatively easy to displace. In this case, the lack of evidence that there had been any change in circumstances between the execution of the will in 2018 and the deceased death in 2019 was enough to rebut the presumption. So, Georgia, if we have a copy will and we're going to use it, how should we go about proving it?
So if the original will cannot be found and therefore lost or has been accidentally destroyed or was located but has been lost since the deceased's death, probate of a draft copy or reconstruction of the will or codicil can actually be obtained. The procedure for proving a copy will is set out in Rule 54 of the Non-Contentious Probate Rules 1987. The application is made to the probate registry, at which the application for the grant will be made and the order can be made by a district judge or registrar. The application must be supported by evidence in the form of an affidavit or witness statement. The evidence must set out the grounds of the application and any available evidence that the applicant can adduce as to the will's existence after the death of the testator, or where there is no such evidence, the facts on which the applicant relies to rebut the presumption that the will was destroyed by the testator during their lifetime. The applicant must ensure that the court has the best available evidence of what happened to the testator's will in order that effect may be given to their testamentary wishes. It's really important to understand what the applicant does not need to demonstrate, that the applicant does not need to demonstrate that the will has been lost. It's the fact of its loss which gives rise to the presumption of revocation. Instead, the applicant must establish by evidence that the will was not in fact revoked. The order can be made by a district judge or registrar who may require additional evidence in the circumstances of a particular case. For example, they may require an affidavit or witness statement of due execution. If possible, it's best to lodge with the application the written consent of any person who would be prejudiced by the application. So, for example, this would be people that benefit under the statutory rules of intestacy who aren't benefiting under the copy will, for example. Where a copy or draft of the will is available and you are making an application to prove that, the affidavit or witness statement should also state where it is the case that the original will was in existence at the date of the testator's death and was lost afterwards, the circumstances in which it was lost, if these are known, and the efforts that have been made to try to find it. This needs to include exhibits such as any adverts that have been placed and stating whether they've actually produced any form of reply. If the original will was not found or available at the death of the testator, the circumstances in which it was last known to be in existence and the facts on which the applicant relies to rebut the presumption that the will has been revoked by destruction. For example, shortly before their death, the testator had referred to their will as existing, but without mentioning any form of revocation. If it is a copy will, the statement should confirm that the copy has been examined with the original will and found to be a complete and correct. If it was a draft, it should confirm that the original will was prepared from that draft, and if after execution the draft was compared and completed from the original. And finally, the statement should confirm who is prejudiced by the admission of the document, their consents if these are obtainable, and whether or not they are over 18. If there is no original will or a copy in any form, but there is evidence of the content of the will when it was executed, an application may be made to prove a reconstruction of that will. Here, the court will require the drawing up of a reconstruction representing as nearly as possible the will in its original form. This is then exhibited to an affidavit or a witness statement verifying its form and content.
So in the case of Wrangle and Brunt, Winston Wrangle, who was also known as Bob, brought a probate claim seeking revocation of letters of administration which had already been issued to the deceased mother, Marlene, and Bob said that Dean had not died intestate. Bob was Dean's uncle. Dean had died in tragic circumstances in December 2007, and in July 2008, Dean's mother, Marlene, had obtained letters of administration in relation to Dean's estates on the basis that he had died in intestate, and therefore she was entitled to inherit his estate. Around 10 years later, Bob had instructed solicitors to write to Marlene, enclosing a copy of a will that he'd found, dated the 2nd of March 1999. He alleged that Marlene had been aware of the existence of this will, but had chosen to hide or destroy the original. Marlene denied the validity of the will, and so the matter ended up in court. Considering the matter in detail, including evidence from numerous witnesses who said that Dean had told them he'd made a will, the court determined that the will was valid, and that Marlene had deliberately kept Bob in the dark about matters. The court therefore set aside the letters of administration that had been granted to Marlene, and the copy will was admitted to probate instead.
So if the original will is found after the order has been made, but before the application for a grant has been lodged, the original will may be submitted to proof. A covering letter with the application for the grant should explain that the original will has been found. If the original will is found after the grant has been issued, it may be lodged in the proving registry. Of course, this can have complications and incur further costs if the estate has already been administered. If the copy will proved was a true and complete copy of the original, then no further action is necessary. If you have a situation in which it appears a person has in their possession or control a testamentary document, but they're not going to release it, or if they simply appear to know about the will but will not disclose that information, then the personal representative should consider making an application to the High Court for a subpoena requiring that person to bring in the document or attend for examination about their knowledge of the will. This can be quite a useful tool to use for us contentious probate practitioners. So I think Hannah and I have covered off the law and procedure involved in lost wills. So Alexa, it'd be useful to hear some case studies from your own practice.
Yeah, absolutely. So I'm going to cover 4 case studies just to give some real life examples of some of the issues that Georgia and Hannah have covered. The first case study relates to the case of A and B, who were a married couple, and this was their second marriage. B had a daughter from an earlier marriage. A had no children. They owned a property together as tenants in common, 50-50, and they'd made a few wills in their lifetime, the most recent one being made in 2017. They each gave a life interest to the other in respect of the property, and then on the other's death, A left her interest to her nephews, and B left his interest to his daughter. A predeceased B. A few months after her death, B contacted the solicitor who prepared the wills and said that A had mislaid her will. There was no attendance note from this meeting. The solicitor advised B that in the absence of any will, the intestacy rules would apply, and B inherited the entire property and then subsequently left his interest in the property, which now stood at 100% to his daughter. On B's death, A's nephews sought to bring a claim that A's estate should never have been distributed in accordance with the intestacy rules, and instead that the 2017 will should have applied. As it hadn't been revoked, it had simply been lost. And we acted on behalf of B's daughter in that claim. Now, the evidence that we relied upon on behalf of the daughter was that the couple had regularly changed their wills, especially A, who seemed to make a new will whenever she fell out with her relatives. Our client argued that A revoked the will because she'd had a falling out with the nephews as they didn't visit her often enough. And we had evidence in the form of care notes in which A had said that she had no family and there was no mention of her nephews or their immediate family. Now, the contemporaneous care notes were independent and provided an insight into the state of A's relationship with her nephews prior to her death. There was evidence that there had been a change in A's circumstances, and so in theory, she had a reason to revoke her will. In addition, A was incredibly meticulous with her documents. She had bank statements and payslips dating back to the 1990s, which she stored in date order, and she carefully stored everything in a filing cabinet at home. This makes this presumption stronger, as she was more likely to have revoked the will rather than having just lost it. Now, the arguments that were raised on behalf of the nephews were that they queried how likely it would have been for someone to revoke a will without making a new one, especially when they'd always in their life made a will. They also focused on the fact that the joint tenancy of the property had been severed, which they said indicated A and B's wish for it not to pass to the other. On that point, we argued that this could be counteracted by the fact that A's intentions had changed since the severance, as her nephews had been less in contact with her. And some other points to consider in this context were whether the deceased had copies of the will and the original. If nothing could be found at all, then this suggested a revocation rather than just the original will having been lost, as in this case. The way that B described the account to the solicitor, the use of the word mislaid, that could be argued that this was a mistake rather than an intentional destruction. In this case, the outcome was that a settlement was reached in correspondence, which I think was the best outcome for the client because there was clearly some risk on both sides. In the second case study, I acted in a long-standing dispute in the Court of Protection between an attorney brother and sister in relation to the property and affairs of their mother. That dispute lasted 2 years, and just as we were in the process of finalising a settlement, their mother died. The brother and sister were both executors and residuary beneficiaries in Mum's will. The settlement terms in the dispute provided that part of the brother's share of the estate would pass to the sister in settlement of the dispute and costs that had been incurred. After Mum's death, they discovered that the original will was missing. The evidence pointed to the brother having removed it from Mum's possession when he cleared out her property at the beginning of the dispute, and he then subsequently lost it. An application was made to prove the copy will, and prior to making the application, detailed evidence from both the brother and the sister was prepared, which detailed their recollection of how and where the testator had stored the will before she moved into a nursing home, and who had had access to the filing cabinet in which it had been stored. We also sought and obtained the consent of an estranged sister who would be prejudiced by the will, under which she was to receive a small cash gift and on intestacy, she would have received 1/3 of the estate. Now, the estranged sister initially sought to negotiate a better deal for herself, obviously seeing an opportunity. And so she argued, I'll consent to your application, but only if I can have all of Mum's jewellery and a bit more cash, please. We informed her quite robustly that she had misunderstood the position, that we would be successful in our application to prove the copy will, and that if she contested that application, she'd lose and she'd be ordered to pay the costs. We politely suggested that she take some independent legal advice, which she did, fortunately, and she quickly returned the signed consent form. Subsequently, the application was made to prove the copy will, and that was approved. In the third case, the testator had made a will via a will draftsman and at the same time had made an LPA. The original will and LPA had been held by the will drafting company, who sent out all original documents held on behalf of their clients to an independent storage facility. When the testator passed away, his nephew, who was an executor and beneficiary of the will, notified the will writing company of his death and instructed them to apply for probate. The will writing company requested the release of the testator's file from the storage company at that point, and when the box containing his documents arrived, they discovered that the will and LPA were not inside. We were therefore instructed to make an application to prove the copy will with supporting evidence. And the application was granted as there was very clear evidence that the original will had not been in the possession of the testator after he had made it, and it had been lost in the process of it being stored with a third-party company. And in the final case study, we acted for a charity which was the executor and residuary beneficiary of the estate. The charity had received a copy of the testator's will by post following her death. The copy will had been sent to the charity by members of the testator's synagogue. She had no family. It appeared that the will had been prepared by a bank, and we conducted a thorough search of the original will. That included a search of her care home room, the belongings and the list of documents and retained items that the local authority were holding, because the local authority had been responsible for clearing the testator's home prior to her moving into the care home. That search uncovered that the local authority were not holding the original will, and they had disposed of everything else that had been in the testator's home. We made inquiries of the bank, who informed us that they didn't have the will in storage and that they only stored wills if they were appointed executor, which in this case they hadn't been. We did an online will search, which didn't produce any positive results. And we also spoke with those who knew the testator, including the testator's rabbi, but they didn't hold or know of the whereabouts of the original will. There was no evidence to suggest that the testator had destroyed or intended to revoke the last will, as she had no close family members, and we therefore had to query why she would choose to be intestate, having made a will gifting to charity. It was possible that the local authority had inadvertently thrown the will away in the house clearance when the testator went into care. And the synagogue had been provided with a copy of the testator's last will and other important paperwork, such as funeral wishes and a previous will, by the testator during her lifetime, and they kept hold of it. She never told them to destroy it, or indeed that she had revoked the will. We made an application to prove the copy will, and prior to doing so, we instructed a genealogist to prepare a family tree to confirm who would benefit if the testator had died intestate. Now, some individuals were identified, but addresses couldn't be easily located. And so in the interest of costs, we didn't contact them to seek their consent. But in the application, we explained why, in our opinion, it was disproportionate and unlikely that the testator was intestate, and why we considered on a balance of probabilities that she did not revoke the will. The application was successful and the copy will was proved. So in summary, the courts require the clearest evidence of revocation. It's not enough that the original will was destroyed. The testator has to have had the intention to revoke it. A will destroyed while a testator is of unsound mind is not revoked. The same test for capacity to make a will applies to its revocation. The burden of proof in shifting the presumption lies with the parties that are trying to propound the missing will. The strength of the presumption of destruction varies according to how the testator had kept their will and how securely they kept it. Each case will turn on its facts. Revocation of a will does not revive an earlier will. Revocation of a will on the assumption that an earlier will revives means the revocation is ineffective. And finally, the presumption of revocation does not arise if the will was not in the possession of the deceased, but a third party, for example, the firm of solicitors with whom the will was lodged. And that's it. We hope you found this overview to be useful. If you've any questions, as Sarah said, we're very happy to take some now. Otherwise, our contact details are on the slides, and we're happy for you to get in touch at any point with any questions you may have. Thanks very much for listening.
Thank you.
Thank you, Alexa, and to Georgia and to Hannah. I have got several questions that have already come in, and there are 7 in total. So I will raise them. If they've already been dealt with, we can go through that. For anyone else that would like to raise one, please put them in the question and answer session, and I can put those as we go through. So the first one I've got on the screen is, what would your advice be to paralegals or other people who handle wills daily? Is there any top tips? It's quite a general question. I'll leave it to you.
I mean, I think that generally the record keeping is the most important thing, to make sure that there is a paper trail in regards to where the will is being stored and who is responsible for storing that. The cases that we've described, one of the most important things is establishing in the evidence in support of any subsequent application. You really need to have that paper trail to build up that picture. So that applies to paralegals, but anyone handling wills needs to be aware of that, so that's it's useful evidence later if needed.
And in terms of will registration, what are your views? I mean, people differ on it, about compulsory will registration.
I mean, I think the most important thing is that people make wills, and that they're not sort of barriers put in place that might put people off making the wills. So registration is obviously a really positive thing, and the more people that register wills, the better. But I think the risk with making it compulsory is that you might put people off, or cause issues if they haven't registered after making a will. So I think that it has to come with that caveat.
I think it's difficult when so few people make wills at the moment to then add that other factor. It would just be absolutely ludicrous that you wouldn't have a valid will if it hadn't been registered. So it's already, I agree, it's going to be a barrier if something does come up. So I think this might have already been dealt with, but what would happen if the will was lost, the deceased person had been administered according to the attestacy rules, and then the will was found?
Yeah, I think it's going to be quite tricky. Essentially, it'll have to be unwound, and it will be really costly. And I think I'm not quite sure how many beneficiaries are likely to want to give money back in order for an estate to be essentially re-administered. So I think it's going to be quite a tricky situation. You have to make sure that whoever's administered it has followed all the steps necessary in order to make sure that they've done it properly in the first place before it can potentially be unwound, because of the risks to them as well.
Big question, isn't it? Because it depends when that comes to light. If it's like 2 months after, or years down the line, because that would depend how long the beneficiaries have in good faith had the funds.
100%.
And then you've got who has administered it, and how around all of that, you've effectively, what steps have they taken? Have they done anything to check that there was a will, or has this will just been hidden and just come to light due to something out of the blue? So yeah, it's a very difficult one, open-ended. What can be done when a will is lost after the testator loses capacity?
In terms of the capacity point, we sort of covered, I think you covered that point, didn't you? Do you want to just remind everyone?
Yeah, so I think in terms of you can't revoke a will if you don't have capacity. So the same test as in Banks and Goodfellow applies essentially. So I think that's the starting point. So the whole when you're looking at wills, Banks and Goodfellow is always drilled into us, but also there has to be that intention, and so there has to be the intention to revoke a will. So if you're going to be destroying it, it's not because it's been lost in a fire or a flood or something like that, and therefore it's revoked by destruction. That's not the case. The case is that you are tearing it up, not putting a pen through it, and you are physically destroying it with the intention that you don't want that will to be valid.
And the next one I've got in terms of questions, I think you've probably gone through this, but what steps should immediately be taken if you discover that the will is nowhere to be found? And I think you covered that in your presentation already. The last two that I've got are what percentages of solicitors or will writers use the will register, and how does it work?
So we're not sure exactly any percentage of solicitors that use it, but you can send the will to them to register the existence of the will. And I think the will register says it's got about 10 million wills registered with it at the moment. So I suppose if there's around 70 million adults in the UK, and I think recently it was only about half that had a will, that's what gives you the stats on how many wills are registered with the will register at the moment.
And then the last one, which has come in, is about wills in different jurisdictions. And I see this quite a lot, where you'll have one will that is worldwide and the other is also worldwide. Sometimes people do go specific in, say, for example, they've got one for England and Wales, one for Spain. So I imagine it largely depends, but what if a testator has two different wills in two different jurisdictions? And that's literally the end of the question, in the sense which will is valid, which one's not. And I suppose in that question it depends on how wide the will is drafted and which jurisdiction it covers specifically. I often see ones from Pakistan or India, for example, drafted and they're worldwide because they aren't limited, which then unintentionally revoked the ones in England and Wales. And the same with quite a few that have come across in the Caribbean. It's very difficult to unwind it when it isn't limited to a specific jurisdiction.
Yeah, definitely. I think you're right. It would be very dependent on the wording of each will, which you'd need to carefully consider, wouldn't you?
And I think that's all the questions I've got at the moment. I'm just going to check to make sure I haven't missed any on the question and answer. I can't see any that have come up, so I'm going to leave it there. But thank you so much to all three of you for presenting. It was incredibly interesting, and I think a topic that lots of people have to deal with quite regularly. As mentioned at the beginning, the webinar is being recorded. It's going to be available afterwards. The slides will be circulated as well. Our third presentation with a private client focus is going to be on the 26th of September. And this time it's being hosted with Shakespeare Martineau, so Helen Wynne and John Turnard are doing that. And it's around dealing with vulnerable clients. So that'll be on a range of things like LARC and UGID requests. So we'll circulate details of that very shortly. For now, we've got a summer recess, so we won't be doing any webinars in the middle. But thank you again to everyone attending and to the speakers. A really useful topic, and I think really kind of useful case law that came out as well in terms of the process behind it all. So thank you everybody for attending, and we'll end it there.
Thank you everybody.